Welcome back to everyone. The next session will be moderated by lecturer Kunzang Dolma. Kunzang Dolma is a lecturer specializing in alternative dispute resolution courses and the director of EDR clinics at JSW School of Law. Kunzang received her LLB degree from Indian Law Society's Law College under Pune University, India, and her master's of law in dispute resolution from University of Missouri School of Law, USA. Before joining JSW School of Law, she worked as a legal officer for district administration in Wangdifodong and then later with district administration in Poro. With this, I would like to request moderator Kunzang Dolma to take the floor. Thank you.
A very good morning to all. Thank you, Thong, for the introduction. I'd like to welcome all our participants to the sixth session of the conference. Before we begin, I'd like to take this opportunity to wish His Majesty a very happy birthday and pray for his long life. In this session, we have one speaker in person and two speakers will be joining virtually. I hope everybody is looking forward to our session because we've had in the previous sessions, we've had speakers who have spoken on policy matters related to public procurement. In our session, we are fortunate enough to have two speakers who will focus specifically on practical who will share their practical experience on implementation of those policies. Before I begin, I'd like to inform that the Q&A session will be after all the speakers have presented. And to the speakers, I'd like to remind that each speaker will be provided 15 minutes. And if you can manage your presentation within that time. With that, let us introduce our first speaker. Our first speaker is Mr. Sonam Jamso. He's a senior planning officer at Dagana Dzongkhag Administration, where his core responsibilities include facilitating and coordinating the formulation of 5-year plans and the annual plans of Dagana Dzongkhag and its GEOX. For this, he also spearheads the periodic monitoring of these planned activities and conducts year-end and midterm evaluations. Prior to this, he has worked at Dzongkha Development Commission as a research officer. He has a postgraduate diploma in public administration from the Royal Institute of Management and Bachelor's of Arts from the Institute of Language and Cultural Studies. Mr. Sonam Jamso, sir, if you can, if you're ready, the floor is yours.
Very good morning to everyone. And thank you, Madam Kunzang, for the introduction. I am actually greatly honored to be a part of this national conference on the public contract, which is a very rare opportunity for us. Firstly, I, on behalf of my Dashut Zongda and the entire team of Dagana Dzongkhag administration, and on my own, would like to thank Jigme Singye Wangchuk School of Law and the organizing team for giving us this wonderful opportunity. Dagana Dzongkhag has been in social media limelight since last year for our monitoring practices in the Dzongkhag. And some people even say that Dagana Dzongkhag has a very robust monitoring system in place. Actually, we didn't do anything extraordinary that nobody has ever done. But whatever we did and whatever we do it with due diligence. And compared to past 4 to 5 years, I can say that, yes, we do have a good monitoring system in place. Today, I will be presenting on the monitoring system of Dagana Dzongkhag. Since we are given only 15 minutes to present, I will make it very brief. My presentation actually covers these 4 topics: tendering process, monitoring of the capital activities, final handing taking of the work, and some lessons learned through this monitoring practice in the Dzongkhag. When I say tendering process, it's nothing new. It's same as done in the other districts. to highlight some important steps in tendering process. Before we upload the tender document in the AGP system, we first make sure that our site engineers present their drawing, design, and estimates to the Dzongkhag Tender Committee for approval. Only upon the approval, upon getting approval from the tender committee, then they upload the document calling for the bidders in the EGP system. After certain duration, and then after the bids are opened, a team from engineer section and sector and accounts section, they form a team and they carry out the evaluation of the bids. On completion of the evaluation of the bids, they present their evaluation report to the Dzongkhag Tender Committee for award of the work to the winning bidder. And one important, after awarding the work to the winning bidder, after completion of some other formalities like sending out the letter of intent and letter of acceptance, then finally we reach to the signing of the contract agreement. Here we give more important in the signing of the contract agreement, because this is the first point of contact between the contractor and the Dzongkhag administration. So for this, we call the contractor along with a witness, and from Dzongkhag administration, we have a team headed by Dash Dzongrap. The members are Dzongkhag planning officer, Dzongkhag engineer, Dzongkhag finance officer, and we also have site engineers. And this team meet with the contractor, and during the signing of the contract agreement, we brief the contractor about the terms and conditions of the tender document. And also we brief the contractor about our monitoring system and some about our bill payment process in the Dzongkhag. And we also give opportunity for the contractor to share his concerns, issues related to his work. In this manner, we discuss and deliberate and way forward. If there are some foreseeable issues in it, it is resolved during the signing of the contract agreement. And after everything is done, then comes the monitoring system. For monitoring system, let me first share who are the members involved in our entire monitoring system in the Dzongkhag. We have so many stakeholders involved in it. Number one, site engineer. He is the most important person in the monitoring system. Site engineer monitors the activity from time to time. And second, we have concerned sector. Concerned sector takes ownership of the work, and that particular sector reports the progress and status of the work to the Dzongkhag administration periodically. And number three, we have a technical team of engineers. They are the very special team. They monitor the works at very critical levels, not in all the activities, but in critical areas, like for building activities, for casting of slabs. It needs a very technical knowledge to monitor the quality of those activities. So for this, a team of engineers, they visit the site to monitor. And this is the very important stakeholder in our monitoring system. We empower, we make sure that end users, our beneficiaries, play a role in monitoring the activities happening in their jurisdiction. Like if it is construction of road, farm road in the community, in a village, that community people are made to monitor the activity time. In fact, they monitor it daily in rotation wise. And number four, of course, GEOC administration. We make sure that GEOC administrations are on board regarding the activities happening in the GEOC. And finally, we have Dzongkhag Monitoring Committee. These are the stakeholders involved in our monitoring system. And if I talk a bit on Dzongkhag Monitoring Committee, it was instituted formally in 2019. Prior to that, we had a monitoring practice in the Dzongkhag, but it was not so well coordinated, well planned, and it was not well documented at the end. Therefore, in 2019, we instituted a committee with the members, Dash Zongda as the chair, Dash Zongrab in absence of Dash Zongda. Dash Zongrab acts as the chairperson of the Dzongkhag Monitoring Committee, and we have district engineer as a member. He looks from the technical angle, and we have Dzongkhag finance officer and also Dzongkhag planning officer. We have actually 4-member committee. Dzongkhag planning officer actually takes the lead role in coordinating this monitoring system. Actually, these members are the ones who are in Dzongkhag tender committee, but we give it a separate name to this committee. In other Dzongkhags, I was told that in some Dzongkhags, the Dzongkhag tender committee monitors all the activities. But in our case, we have different name, although the members are same. But during the time of monitoring the activity, it is not only these 4 people in the field. We have all the stakeholders which I presented earlier together with us. And during the time of monitoring the activities in the field, we come up with a monitoring report, which is very important for our necessary follow-up after coming back to the office. When we are in the field, wherever we visit, we write down whatever we observe, like how many machineries were deployed at site, how many workers are there, what are the works completed, what are ongoing, and if there are any issues, any good practices, good things happening, whatever we observe, we write down in the site order book. This is the site order book page. It is maintained with the contractor. And also we write down the directives from the Dzongkhag Monitoring Committee to the site engineer and the contractor. With at the end, we make all the people present during the site visit sign the document. And this particular concerned site engineer, he or she takes the photo of this site order book and shares it in our monitoring Telegram group. We have a Telegram group wherein all the engineers are there and GMC members are there. So whatever we write, they share it in this Telegram group. And after we get back to our Dzongkhag, to our office, then I compile all those, whatever we had written in the side of the book in this monitoring report format. And I share it with the concerned sectors and stakeholders for necessary follow-up action. So when we say Dagana Dzongkhag has a robust monitoring system in place, what I feel is that we have some features which makes our system more robust and more stronger. Some, if I mention, share here some. Number one, we make it a more frequent visit to every site. At least a minimum of twice or thrice to each activity. If we have non-performing contractors, if we have a weak contractor, we make, sometimes we happen to visit around 6, 7, 8 times. In one of the constructions, we visit monthly. On 12th of every month, we visit because that contractor has failed miserably. So we actually want to monitor monthly. And so far, we had been monitoring for around 8, 9 times in that particular activity. And also, like I said earlier, engagement of all the stakeholders. we engage all the stakeholders in monitoring process. Last year, if I remember, in one of the BBS news, one of the GUPs in the Eastern Dzongkhap was complaining that Gyok administration is not aware of this issue since the activity was implemented by Dzongkhap administration. But in our case, at least we do not have this kind of situation, because from the day one, we engage all the stakeholders involved in it, so that at the end, every one of us are on same page. We are on board. And number 3, my Dashu always says, we have zero tolerance to the inferior quality work. And these 3 features must be adding towards the robust monitoring system in the Dzongkhap. And when it comes to the final handling taking of the work, we have developed a procedure which is working quite well here. And this we even presented to the contractors, and we saw a good buy-in from the contractor. Number 1, before contractor submits the completion report to the Dzongkhap administration, he or she must consult our site engineer. And site engineer must verify the work, and if he or she thinks that yes, the contractor has done everything perfect and it's complete, then contractor submits the completion report countersigned by our site engineer to the Dzongkhap administration. There is wisdom behind having the site engineer countersigned on the completion report, because in the past, some contractors, they submit the completion report when they reach their work progress at around 95, 96%, only to avoid liquidity damage period. So after the completion report is submitted to Dashu Dzongda, then we form a team called Assessment and Verification Team, which is headed by the concerned sector and site engineers and accountant. There will be 2 to 3 engineers that time. So this AVT team will initiate assessment and verification of the work within 7 days from the day of receiving the completion report. So as when they go to the field during the time of assessment and verification, they will first check if everything is done as per the bill of quantity, if it is with as per our tender document, and also if all the recommendations or suggestions provided by the earlier monitoring committees were done or not. They will do a final measurement of the work jointly with the contractor. And during the time of assessment and verification, if they see some rectifications to be done by the contractor, then they list down the rectification works in their site order book and direct or inform the contractor to carry out the rectification work. And if after the completion of their rectification work, contractor must get rectification clearance from the end user beneficiaries. So after having a rectification clearance from the end user, then this AVT team will submit their assessment and verification report to the Dashu Dzongda, chairman of DMC, along with the rectification clearance within 3 days. And if there are no rectifications at the site, they will directly submit the assessment and verification report to the chairperson within 3 days. So after receiving the assessment and verification report, then the Dzongkhap Monitoring Committee, coordinated by Dzongkhap Planning Unit, initiates handing taking of the work within 7 days from the day of receiving the report. And one major change in our handing taking system is that earlier, after handing taking, only then the site engineer and contractor initiates final measurement of the work. But now, after we made it that after handing taking of the work, there shall be no rectification work and no measurement work after the handing taking. So in this entire process, every one of us are equally responsible and equally accountable. Number one, we have site engineer, contractor, then AVT team. If that AVT team does not perform well, then he or she will be accountable. Then we have DMC, Dzongkhag Monitoring Committee. And during the time of handing taking, if our site, if our beneficiaries, if our end users, like if it is in the village, community people, if it is in school, school management, if it is in the hospital, doctor and the hospital management, if they are not satisfied with the quality of work executed by the contractor, we never ever take over the work unless they are satisfied. So this is the process we are practicing, and it's going well so far. And I think this is my last slide, some lessons learned through this monitoring practice. As I have
sir,
already...
you're exceeding 2 minutes.
Less.
If you could end sooner.
Yes, I think this is my last slide. As I already mentioned, if we engage our end users in our entire monitoring system process, they take better ownership of their work and the infrastructure. So it's always better to engage our end users in our process. And number two, we, Dzongkhag administration, conduct annual contractors coordination meeting. So for this year, we conducted in January, and around 49 contractors turned up for the meeting. During that coordination meeting, we call all the engineers together, accountants, sector heads, both the dashos and all the contractors together in a room, and we deliver it for one day. So I think this kind of platform is needed for our contractors so that they can share their grievance, they can share their issues, challenges faced in the field openly to the management. So if we provide this kind of platform for to the contractors, it's always better because we get to know more about our contractors, and we build a good relationship between our contractor and the Dzongkhag administration. I think this is all from my side. Thank you.
Thank you so much, Sir Sonam, for sharing with us the monitoring system at Dagana, which is addressing a lot of gaps and trying to link those. In addition, even recognizing the role the contractors play. With this, we will move on to our second speaker. Our second speaker is Mr. Karma. He is the project manager for the law school construction project. He started his career in procurement of works in 1995 and later worked as a lecturer at the then Royal Bhutan Institute of Technology. He also served as the principal of Construction Training Center under the Ministry of Labor and Human Resources. He was also Chief Program Officer at the Vocational Education and Training Division. He has a diploma in civil engineering from Royal Bhutan Polytechnic Dewathang, a BTech in civil engineering from REC Warangal, Andhra Pradesh, India, and a master's in public administration from Australian National University, Australia. Chief Karma, if you can take over the floor.
Las Kadinchela. I'll first share my screen. Is my screen visible to everyone?
Yes, La.
Las, in the interest of time, I will quickly begin. Yes.
Sorry, Chief, you have to share it again. Your screen is visible, but the document has not been shared.
Okay. Stop sharing. You still can't see, right?
Not the screen. now we can see.
You can see, right, Las?
Yes, yes.
Okay. Nasola, in the interest of time, I'll try to skip the further introduction, but definitely join the organizer, the participants, and rest of the citizens to wish His Majesty the King the very happy birthday and wishing a long life and good health. My presentation, as already the moderator has mentioned, is more to do with the implementation challenges aligning with the public procurement rules and regulations. And the outline of presentation covers mainly 3 sections. First one is on understanding of public procurement and its process. Second, some of the gray areas during practice. And finally, we'll try to submit some recommendations. From the presentation made by the Honorable Secretary Minister of Finance yesterday, and then Mr. Tandin Doji from DNP early this morning, my section 1 would be very fast because there is not much that I need to do. It is to do with the objective of public procurement, which has been already clearly explained. And then there are types of procurement which is to deal with the goods, works, and then the services. And in terms of my focus of the presentation, obviously would be more towards work based on my experience. So in the category, all these things are covered earlier by Mr. Tandin. And then also in response to the difficulties faced, and especially in response to the COVID-19 situation, the introduction of this simplified procurement rules and regulation had been a major breakthrough to make the implementers very comfortable. So these are some of the changes from PRR 2019 to 2021, which was already highlighted. So going on straight to some of the gray areas, and I would like to submit here that these are purely based on my own experience being involved in the construction world. So this is not to criticize the policy level or make critics to any agencies or individual. So as you can see from here, in the process of the project, the ideal process should be such that, the idea of any kind of construction project is generated, and then that gets translated into concept. Then from there on to design and costing, and then from which we determine, we confirm the pricing. One second, my screen is having some difficulties.
So should we
sorry, it's okay, that's fine. I've managed it because there's some overlapping screen on this laptop which I'm using. So based on the design and costing, we need to secure the funding and then do the selection of contractor. After selecting the contractor, again, the difference between the cost fund earlier secured and the cost submitted by contractor is reviewed. And then from there on, the confirmation of funding needs to be done. Then we implement, and towards the end of the project, again, the cost is not necessarily a constant value. Then we need to do the final revision of the cost, and that then later we end the project. But in my experience, the normal practice, even though the first 3 stages follow the same, but somehow the fund is more or less locked. And when the fund is locked, then no matter what kind of design, what kind of concept that we develop with, we need to make the readjustment of the design and costing. And then only we do the selection of contractor, do the implementation. And as we do the implementation, based on the kind of design and the scope of work and available fund, we have to carry out the revision of the funding based on the approved budget. So the problem lies here when a ballpark figure for any kind of project is already allocated and we have to work towards that. And next is towards the end of the project, when we land up into deviation of the costing. So especially when the fund, the cost of the project exceeds the approved fund, we tend to have a problem here, Sijunil. Now, next is on some of the flaws related to estimation of work. The procurement rules and regulations has clearly specified that when the budgetary agencies do the estimation, we have to do a thorough market research based on whatever design or intended project is being conceptualized. Likewise, the normal situation, under the normal circumstances, the BSR that is generated by MOWHS also clearly states that it is generated only as a reference purpose and not to be used as a direct basis for determining any cost of the project. Unfortunately, the normal practice is doing exactly what we are not supposed to do. For whatever reasons, there is lack of intensive market analysis. The site conditions, I think yesterday the official from Royal Audit Authority also mentioned, are not assessed. No visits are taken place during the conceptualization and design stage. And under most cases, I would say 99% of the time, BSR is blindly adopted by estimator as well as bidders. So that is where, the result is when we use this kind of basis without really understanding the site conditions. When we put garbage in, the garbage obviously would come out. So continuing with the estimation of work flaws, we are still struggling with the details in the design. In my experience so far, I have hardly come across any kind of construction design. Majority of the time, it is mostly conceptual design and to some extent a detailed design in which a complete package of what is required for the construction are not there. Likewise, the interior design details are not provided. The MEP drawings and information are very basics, and specification of materials are not predetermined concretely. Then the other thing is with the rate analysis. I remember when I was doing my diploma sometime in 1992 and 93, this is the same formula that we have come across. And the basis of rate analysis was taught to us using the estimating and costing book, which was produced sometime in 1984 in India. So here, I will not go into the detail, but then apart from labor, machinery, material, the other factors that are included are 5% contingencies, 1% water charges, and 10%, which includes overhead and contractor's profit. The problem I would like to highlight here is what happens, because there are so many changes that has gone place. However, the coefficients of labor and material never changed. Likewise, those rate analysis which was derived then was on a very basic basis. And now we expect that construction companies should be full-fledged with full management system in place. Unfortunately, there are no cost factors. There are no coefficients included for the technical team members, for the management team members, for the HR team members, where requirement is very stringent on the part of the contractor to fulfill. Likewise, everything is subsumed under 5% contingencies and 10% overhead and profit. Now, at the real site condition, there are so much of wastages. There are costs related to transportation, especially during this COVID time. Bringing in material from across the border, Jaigong to Phuntsiling itself cost huge amount. And there are other factors like taxes, establishment cost, clearances, insurances, which are not really spelled out. And then the interesting thing for us to understand as we talk about using the market analysis. Now, from 2015 till 2018, BASR, even until 2020, if you look at the labor rates that is being used for the analysis, you can clearly understand the changes that has taken place. At least in 2021, there has been a major revision on the labor cost. However, if you really look at the existing market rate, this is still more than what was already taken into consideration. So the other aspect of challenges that we encounter is packaging of contracting system. Just to understand, there are mainly 3 systems, which again, I think it has come out as a revision in PRR 2019. From number 1, lump sum, to number 2, item rate contract or at measurement. The third one, cost plus, is also specified, but in a real situation, I'm not too sure whether that is still implemented or not. And the problem is not about the revision of the procurement rules and regulations, but problem is, as I highlighted earlier, the basis of estimation, the accuracy of estimation. So the other thing is about the contractor selection process. I have borrowed this one from CDB website. And in this, there are 2 processes. The first stage is about the technical qualification. And then after getting through the technical qualification, then you are being evaluated based on the financial bid. So on this, the CDB has already submitted some of the gray areas. Now, the new entrants, the new contractors, and those contractors who had no work in hand automatically gets disqualified. So this issue was already submitted to Ministry of Finance, and I'm sure the policymakers have already taken that into consideration. Earlier, we heard from Tandin Doji that they are still reviewing and making it more convenient for the bidders. So the other thing that we also had experienced is, even though the technical evaluation is the first stage of bidding process, it is still more of theoretical. Majority of the budgetary agencies, when they do this evaluation, these are done much more theoretically. Somehow I feel that the practical aspect is lacking. And then it is good idea that there is a provision created for scoring of employing Bhutanese, TTI graduates, providing apprenticeship. But then the ground reality is people just use certificates. And when we're at the implementation level, when we are at the site, we hardly notice those people. So the other thing is award of work to technically lowest evaluated bid. I think here I will not cover, because earlier the DNP official mentioned that there are some issues with this and they are looking at it now. Then the next is deviation limit within the 20%. Now, in the way this is formulated, I do not see as a problem, but because there are a lot of loopholes in the accuracy of estimation, so this triggers some concern. Then other thing that all of us need to understand, as viewed on 20th January 2022, during the preparation of this presentation, there are about 2,931 contractors, inclusive of large, medium, and small. And there are some 1,589 contractors registered. So as Dashu Secretary, Minister of Finance mentioned yesterday, at any given time, so depending on the scale of work, this many people, this many registered contractors need to have work in hand to be active. And the consequences when they do not have work, this is where I personally felt that the ghost contractors or briefcase contractors are generated. There are so many subcontracting taking place in the market. And the syndication, I think earlier one of the key speakers mentioned about some kind of contract rigging. And then the EGP initiative, which is very good, I personally really appreciate, but the stages, now we were informed that the third phase would also be finalized anytime soon, but it is high time that we start reviewing the initial 2 stages and the problems with that, because majority of the contractors, the education level are so low that they probably hardly get any opportunity to participate only. And as a number of contractors being much more against the number of works that are available in the market, perhaps that could be one of the reasons why there are so much of underquoting. Then the other...
You're already exceeding your time. Just for information, 5 more minutes left.
Okay, okay. Thank you so much. Then the other thing is, yes, the procedure versus outcome. And sometimes we feel that we are too much into procedure. Firstly, the rules and regulations. Secondly, the auditing process. And because of rules and regulations and auditing process within our own system at implementation level itself, we come up with so much of procedures. And then the real essence of the quality outcome is being lost. Second, penalties versus reward. In some ways, all of us are severely into making a good move towards penalizing for the wrongdoers, but somehow rewarding the ones who does good are silent. So conclusion, I have come up that we perhaps need to critically look at these areas to review. Now, drawing design specification estimate, first thing first, and doing the first time correct. Unless that is accurate, the rest of the initiatives that we take will be nowhere. I know that Ministry of Labor and Human Resources are in a continuous journey of improving this rate analysis and BSR. We really need to continue doing that. And evaluation criteria is already touched upon. And then project cost consideration. Here, earlier, it was mentioned that the EMD is 2% of up to 2% of the estimators. And when the estimation is wrong, so that is where the bidders tend to assume the cost of the project based on the EMD value. So this is something to be looked at also. And then the advances system, now this simplified procurement rules has revised, and we still need to look at to make it more dynamic in terms of advances, in terms of payment system. And then, like mentioned earlier, somehow come up with some ways to check and balance the contractors who are actually non-functional by themselves in reality. So all these processes of work to be linked with outcome. And then it was already mentioned that now a direct contracting system or selection process are being improved. So assessing the relevancy of the open tender is also must. So finally, yes, all of us can really resonate to punish the wrongdoers, but we also need to equally focus on incentivizing. Sometimes that might help improving our systems.
Thus, thank you very much for your presentation, sharing your experiences and challenges that are faced in implementation, as well as giving us recommendation as to what has to be looked into to improve the policy. Our next speaker is Migmar Ham. Migmar Ham is a lecturer at the law school. She teaches corporate law and serves as the faculty for the Social Enterprise Clinic. Prior to joining JSW Law, she worked as a senior legal officer at Bhutan Alternative Dispute Resolution Center, where she also served as the member in the drafting of the Alternative Dispute Resolution Rules and Regulation. She is also a mediator. Migmar holds a BA LLB from CMR Law School under Karnataka State University, Bangalore, India, and a postgraduate diploma in national law from the Royal Institute of Management. Migmar.
Good afternoon, everyone. So I'll directly get into my presentation. I hope am I audible? Okay, thank you. So the topic of my presentation is application of mandatory binding arbitration and alternative means to a peaceful resolution of contractual dispute in the public contract. So this is the paper that I have written. So in this presentation, be it a paper, I have two different parts. The first part is about in the first part of the presentation, I'm going to discuss about the existence of our arbitration as an alternative means for the domestic public contract. And in the second contract, in the second part of the presentation, I'm going to focus towards the application of mandatory binding arbitration in the public contract as a peaceful contractual settlement mechanism. So under that, we have three different features or three different subheadings where I'll be discussing about. So I'll directly move into the first part of the presentation. That's about the existence of arbitration as an alternative means to peaceful dispute resolution in domestic public contract in Bhutan. So in Bhutan, the ADR, the alternative dispute resolution process, is a backbone of how the justice is done in the Bhutanese legal system, which has been otherwise in the Western countries. The dispute resolution system has been in place from the time immemorial in our country, and it's basically a village-based dispute resolution method. It is never an alternative for the Bhutanese. It has been our way of settling the dispute in the country. And now the emerging of the term arbitration, which has been very catchy phrase in our country since it has been quite recent from year 2015. But then the existence of the arbitration as an alternative has been into our system in the construction industry, which has been created in the year 2004 by the 7 members in the construction sector. So basically, it was administered or facilitated by the CTB, which was then still under the Ministry of Work and Human Settlement. So that's called as an interim National Arbitration Committee. And the legality of this, our ADR, or be it a negotiation, mediation, or arbitration, got its legality, or legalizing the word has been in place, like got that legalizing point of view when the Bhutan, the first parliament, when enacted the Bhutan Alternative Dispute Resolution Act of 2013, but then that act came into existence when our constitution under the Article 21, Section 18, when under the Section 16, when it was the government who has it is there. It's there in our constitution where it is mentioned that Bhutan need to have an alternative dispute settlement center to resolve all these issues, and this is where the existence of the arbitration came into existence. And now, if I jump into my another slide, that's the application of mandatory binding arbitration. The word arbitration and the mandatory binding arbitration as a two different definition altogether. Arbitration being a process where we have the independent person resolving a dispute in a less formal way than the court. Resolves the dispute. And when we have this mandatory binding arbitration, the term mandatory binding, in our public contract, we have this imposition of mandatory binding arbitration clause in the contract, which has been clearly stated under our standard bidding document, which is also a part of the public contract agreement. Document. It's quite a bulky document, you know. When I was referring that, it was like 106 pages. And in the GCC, where general condition clause, we have clearly mentioned that it is clearly mentioned that the contractual dispute has to be solved through an arbitration, which further linked to the SCC, which is a special condition out there, how the arbitration is done, how it needs to be done, and where we have to refer. So definitely it was a CDB previously, and now it is a Bhutan ADR Center. Now the government has come up with this simplified procurement rules and regulation 2021, where the government has given an option to the procuring agency to choose whether you wanted to arbitrate or whether you wanted to go for a court proceeding. So this option is created out here, but then I will discuss further down the line, having created an option, how that's going to again further deprive the other parties in the contract. So now I would like to go to my another slides where application of mandatory arbitration in the contract. So basically, I'm going to discuss on discuss as well as this. It's still a paper in working, so I would like to take the comments as well. So how having a mandatory binding arbitration in the public contract is a debatable or a point of discussion for a public, how it's going to deprive the another party and how it's going to benefit the certain portion of the another parties in the contractual agreement. So when we hear about the word arbitration, it is a choice. It is a choice to the party to select or put it in the contract. But then our standard bidding document, do we really have a choice? It is because it is there in the contract. It is a mandatory binding to the other parties. So my question out here would be, is there a mutual consent from both the parties or not? So because when the parties to the contract sign a document, it's a contract agreement in the public contract, the one party knows already. It would be the party who is aware is always from the government side. So RGOB contract. So in the RGOB contract, the government has drafted this contract agreement, and they're already aware about the clauses or agreement or whatever it is there in the contract. But another party who is a private contractor or the consultancy or the firm or an individual, they may not be aware about this the features in the contract. So for example, when we take it, this mandatory binding arbitration clause in the contract, do other party know about what is there in the contract? Because when we sign a contract, there has to be a mutual acceptance from the both parties, or for an acceptance has to be there. So here, the fundamental feature for an arbitration would be always a mutual acceptance. And here only the one party is accepted, and the another party is sometimes it's completely based on my research as well as an interview that I have with the relevant stakeholders. They are not at all aware about the arbitration clause in the contract. So so we always call it like, is the arbitration clause has been always a quick primer in the contract? Is it just a small piece of document inside where the parties are not aware, and it has a great repercussion on the parties when there is a issues or the dispute or the differences when they have it? So it's a non-fact to the Bhutan ADRC Center or the judiciary or to the parties that they are really not aware about this arbitration clause having in the standard bidding document, or not having a choice to them. Sometimes we really have to ask the question that where are we lacking, or are we lacking in the advocacy, or are we lacking from the point of the legal literacy rate or not? Now, if I move to my another topic of the discussion is like having the mandatory binding arbitration clause in the public contract, whether so it's basically we all as a Bhutanese are given that right to approach to the court in the matter arising of whether it's a contractual, whether constitutional, or whatever it is. We have that right to a fair and a public trial by an independent and impartial court. And now, since the parties to the contract, so let me take an example. It's basically a construction related case, which the ADR Center gate is 95% of the cases are from the construction related. So the parties there, if they have an issue, they do not have the choice to go to court. They directly have to file the cases in the Bhutan ADRC Center. And they are deprived this statutory right to approach to the Royal Court of Justice. My question is, shouldn't the arbitration clause has been a choice? It should have been a choice to the parties rather than being making this as a mandatory upon the parties to get some work. As we are all aware about the economic status, socio-economic status of our country, people to get a work, be it, as the Chief Karma has mentioned, there are so many, we have like 2,000 plus contractor listed, and when we have the limited work, we create this course contractor, and at the same time limited work. And when we compete for that, people normally don't look into the contract agreement as a wholesome. They're more interested into the contractual amount, the contractual period, and signing the documents just takes 30 minutes. And we never had the pre-bid or the bidding system negotiation, or maybe the procuring agency negotiate with the contractors in terms of like amount or a period of the completion. But the other party, who is always a contractor, do they have privilege or a say over the contract to negotiate all these things? So it is directly, I felt that it's directly depriving their statutory right to appeal to court or have their cases tried in a court because of having the arbitration, mandatory binding arbitration clause in the contract already signed by them. And also, how fair is this mandatory binding arbitration to our parties? Yes, the arbitration is done in the Bhutan ADRC Center, but then the key component that we have is like the attraction for the center has been always like speedy trial and cost effective, time saving, and we go with this confidentiality under the section 90 of the Bhutan ADRC Act 2013. So we really don't know about the outcome, and the critics do not have an access to that secret box, which is already there. So sometimes it is very questionable. So going by this mandatory binding arbitration, how fair it is to the parties, to the contact. Um, so the another point would be like arbitration should have been a choice, and now that the parties has choose to go by the arbitration agreement in the government in the public contract, so is it a better choice? Is it a better choice for our contractor or our any other individual who is party to the public contract? So it's a common understanding that arbitration is fast and better than the court litigation. And that is the term that we use to sell the arbitration service to our citizen. But at the same time, sometimes we really need to ask to ourselves or ask to the party who are asked to ourselves and relevant stakeholders that imposition of mandatory binding arbitration in a public contract is a better choice for our citizen or not. Because yes, every coin has a two sides. There must be a people like when I really review this strategic plan of Bhutan ADR 2020 to 2023, there are a set of people who has been quite happy with the services and having the mandatory arbitration a part of the public contract. But at the same time, there is a question about the capabilities and the ethics of our arbitrator raised in this strategic plan or the studies done by our consultant here in the country. So my I still stand by my opinion that arbitration should have been a voluntary choice by the parties rather than having this imposed upon the citizen as a mandatory binding arbitration, because we all know the level of the literacy that we have in the country for the elderly people. We cannot sometimes just go by what is there in the document and say that, see, you are the party who signed this document, you should be aware about it. But the party do not have a say on it. Sometimes for the survival, people go ahead and sign whatever is there and they silently go ahead and sign the documents. And sometimes we just feel they are the puppet and acting on the behalf of the procuring agency and go ahead and sign the document. But then right now, to my conclusion, I still I'm still for me, the having a mandatory arbitration is still a concern in the public contract document. And I'm also during my studies, like for this paper, the research paper, I have referred a couple of research documents from the West as well. And I go ahead with the Professor Jean's statement here that I and many other opinions of the private mandatory arbitration has frequently asserted that binding arbitration is fine and indeed the desirable dispute resolution technique, but only as long as it is a voluntary. I still support this statement, and thank you so much for giving this opportunity to the organizer team as well. And I also joined the nation to wish our King 42nd birth anniversary, and thank you so much for protecting us every day. Thank you.
Oh, so sorry. I believe I have not pressed the unmute button. We will now move on to the Q&A session. There is no question left on the chat box or hand raise icon. So I will take the opportunity to ask the question. There's a question that I am meaning to ask because that's the role of the contractor. Although all three presenters have important aspects in their presentation which deserves focus and discussion, but I am going to take this opportunity to discuss about the role of the contractor because first of all, unfortunately, we couldn't get any contractor, supplier, or consultant to take part in this conference, but we all do recognize their role. And so, and because all the three speakers has mentioned their role, I will take this opportunity to discuss about that. My first question is to Chief Karmala. Although you didn't get much time to talk about this in your presentation, but you've definitely mentioned this in your paper about the role the contractor plays and how sometimes at certain point in the tendering, having to reveal the project cost leads to the contractor's failure to costing the project wrongly. And you've also talked about this syndicate among our contractors in Bhutan, where certain contractors get the work, but it is subleased to other contractors. So my question to you is, are there anything that you can share with us on how to overcome that? Should there be a policy or a strategy put in place? And if there already is, which I am unfortunately unaware of, then how do we enhance them to prevent these?
Nas Kadichela. All of us are very good in foreseeing the problems, but definitely not expert in providing the answers. Now, about the role of the contractor and the way they submit the costing first. As I was mentioning, firstly, I'm not trying to generalize that every contractors are doing that. And in most cases, as I mentioned, the problem begins with the accuracy of the estimation of any kind of project. And for obvious reason, it is important to declare the estimation value from where this contractor is required, for instance, to deposit 2% EMD. So here, those contractors who fail to do due diligence, they straight away take the cost of the project calculating from the EMD. And that is where oftentimes we see the challenges during the implementation, because at the time of implementation, the huge deviation takes place because of loss in the estimation. So on this, I think the solution lies in the professionalism, the capacity development, or emphasizing more on the implementer side in terms of coming up with accurate estimation. That is how I look at as the solution to this issue, not necessarily from the contractor's perspective as such. On the other hand, about this syndication, and again, these are not heavily visible, but there are definitely some practices that all of us know. And Bhutan is such a small country, and we, if even though from all this number of registered contractors that we have looked at, if you really go around and see how many, for instance, large contractors are there who are really established, we can try counting the numbers by visiting their offices, by looking at their establishments. So that is where we foresee as some form of subletting going on, and then some form of whether it is through online or offline, everybody knows what is going on. So some sort of syndication can be there, but in addressing these issues, I really am not the expert, but the fact that all of us are understanding the issue and all of us are recognizing that there is a need, because right now, from all the keynote speakers, we are understanding that we are in the process of journey. So together, I think we should come up with a solution to address and to at least curb these kind of challenges. Thank you.
Las, thank you very much, La. Like you said, again, it goes back to your initial comment about doing the correct estimation. And although the question might be too much for this one in a short span, but like you said, recognizing that there is this issue and then working towards it in a bigger scale. Las, thank you. La. We have two or one on the same line question on the chat box, la. And that is addressed to Madam Migmal Hamla. So the question is, do you think there is a lack of code of conduct for arbitrators? Is that an issue, Imevan? And or the fact that they are getting paid, is that the issue? So it's in a way two ways.
Second question, ignore question, an incomplete question, ignore Benala.
Last, Dashu, do you want to read your question now once to get it for us to understand clearly? La? Last, then the question is, do you think there is a lack of code of conduct for the arbitrators?
Ani, do you think the lack of code of conduct for arbitrators is an issue? Nalu, ani code of conduct dangbangagiri yugami gaya mashila. I don't know whether there exists a code of conduct for arbitrators or not. If not, then is that an issue?
Lesla, Tasho, thank you so much for this question. When I was doing a research, I did look into the code of conduct of our arbitrator as well. Yes, we do have the code of conduct. We had in the rules and regulation of the ADRC 2019, but then the center has removed that rules and regulation would subject to the amendment, I believe. Could be issues, Shunila. It could be an issue because when the strategic study was done for the Bataan ADRC for 2020 and 2023, it has been clearly pointed out that there has been some capacity of the arbitrators has been pointed out, and at the same time, there were, when I was doing an interview with a relevant stakeholder, when I say the relevant stakeholder, this also includes the legal officers and the representatives from the contractor as well as the government officials, and mostly I was focusing towards the contractors here, and we did had a discussion keeping this as an anonymous for the academic purposes. We did had an issue pointed out in terms of the code of conduct of an arbitrator, and we really need to look into Seshunila, but then I haven't carried out the detailed studies on it. Say,
Lasla, anybody on any follow-up question regarding arbitration? Yes, we have Madam Namgyoam. Madam, if you would like to.
Hi, La. I have a question for Madam Migmal. I just wanted to ask her, in your experience with the ADR Center, what do you think could be done to improve the arbitration system? La? Because if the arbitration system was something that was working, then we would not have the issue of contractors not being aware about the arbitration clause, because the system would have been working really well. So what do you think could be done to really improve the arbitration system and enhance people's faith in this? Thank you.
Lasla, Ma'am Namgi, thank you so much for your question. A very broad topic here. Lots of things that need to be done. So, I would like to say that because of that, there was a strategic plan has been outsourced, and there is a strategic plan put in place where we had to look into so many different topics or the different fields, be it from the human resources or be it from the arbitrators capacity building or the capable their code of conducts need to be a more advanced than what we have right now, as well as from the financial incentivization to our arbitrator as well, and the international layers with the international institution to have that international standard arbitration center in the country. So basically, if I really share from my personal experience, it all boils down to the code of ethics of an arbitrator and their capacity building, which we really need to look into right now, be it from the center's perspective or be it from the any relevant agency who are connected with the center. This is something I really personally feel that the center really need to look into to upgrade our arbitrators or the mediators capacity, and their code of conduct has to be really put into first place, and the auditable or the accountability which we need to fix towards them. So
we have another question, and I think it will be in the same line. Madam Sonam Yangdin, if you may proceed with your question.
Am I audible?
Yes, la. Yes, la.
Ma'am Migma, since you talked about the mandatory provision for resorting to the arbitration jurisdiction for dispute settlement, I want to ask you, when it comes to the ngachigi, for the referral or for the appeals, we have that doctrine of policy. Since there is a dominating position whereby the government agencies are the procuring agencies, do you think that this non-giving option for not leaving option for the private party to whether they want to select the arbitration as their jurisdiction for dispute settlement or not, is the policy question, or can we appeal to the High Court on this sole ground? Thank you.
Lesla, Ma'am Sonam, thank you so much. The question. Yes, we had this binding arbitration. We have this mandatory binding arbitration clause in our standard bidding document where both the two parties has accepted, and my this research paper completely focused towards that, having a mandatory binding arbitration clause in our standard bidding document, which is a part of the public contract agreement for both the parties. Is it constitutional? That's my question, which I have raised in my paper. And is it fair enough for the other party, or maybe for both the parties, to have the mandatory binding arbitration clause in the contract? And there has been a certain section of the people who really, because I'm speaking from the point of view of the data that we have when we did the studies on the strategic plan, there have been set of people who are happy, and there are other side of the people who are not happy with having the mandatory binding arbitration clause. And to the party's surprise, sometimes they are not even aware about having the clause, but that is the ignorance of the law. I would definitely say that and blame the parties on it. But then the government did look into this policy. I would say it's something to do with the policy or maybe the legal law from the act point of view. Government is looking into it, and we have this simplified version of the PRR 2021, where the government has given an option to the procuring agency now to either you go ahead with the arbitration or you go with the court proceeding. So now the government has created this option for the procuring agents. Now my criticism out here would be, why is there not an option for other party who is a private consultancy or the private law firm or the contractor out here? Why we do not have an option there? But still then we have a room out here to negotiate with the procuring agency to go ahead with the code of proceeding, or either accept for the voluntary arbitration or create a scope in the contract agreement. Yes, if the arbitration failed, we'll go ahead with the judicial proceeding rather than accepting the arbitration award as in final and bindings. So we have this option created, and I'm very thankful to the Ministry of Finance that something new has been come up now for our private parties to think over and talk to procuring agency. Thank you.
Thank you very much. Any additional question on it? But before that, I saw Sir Tandin Doji's hand being raised. Do you still have a question, sir? Tanji, do you have a question?
I raised and I lowered it again, actually. So, okay, just a quick comment on Ma'am Migmar. I think what we need to understand is there's a slight difference between, I think, a normal contract agreement that is been executed between two individuals, and then the normal procurement process na be the standard contract terms and conditions la. I think it's the same elsewhere, whereby actually the bidder would not have much option rather than to comply by the standard contract terms and conditions la. And secondly, on the bidders not knowing about the existence of such terms and conditions, what we really need to know is that first of all, these contract terms and conditions are, while the tendering process takes place, these documents are shared to the contractors at the first place. So with the understanding that they should have gone through all of the contract terms and conditions, all of the bidding terms and conditions. And secondly, there's a provision for clarification. If they are not satisfied with the decision of or if they are not satisfied with any of the conditions, then they have the option to clarify before the submission of the bids, and even in fact before the signing of contract. And then thirdly, they sign something called the bid submission sheet. So bid submission sheet is an undertaking from the side of the contractors. It's an undertaking stating that they have gone through all the terms and conditions of the bidding process and the contract, and they would abide by its undertaking jimbela. So I think all these mechanisms are in place, but of course, like you mentioned, the problem is the contractors not going through the contract terms and conditions and of course on the awareness on our part. So I think the awareness, it's a continuous process in collaboration with CDB. We are carrying out awareness programs, so we hope all this would be sorted out. And on the option of arbitration, the mandatory arbitration ki theka hibdalu ani de tat ngachi jurche begobi ki migin ngombara la to the agencies the chica consultation so be the major concerns agencies raise is the integrity of the arbitrators that's and because of all these concerns raised, then now we have included a new provision in the SPR, whereby we are saying that it's an option seller. So contractors agency arbitration jonna or whether they want to choose court, that's left up to the agencies while preparing the tender documents. Last karishela.
Okay, thank you so much, Tandin, for clarifying the doubts and all these things. Yes, definitely. I definitely stand by your statement out here as well. Now that government has been started thinking on the mandatory imposition of the mandatory arbitration clause upon the parties, yes, now we welcome that the revised provision, the simplified PRR 2021, having the procuring agency an upper hand on deciding the dispute settlement mechanism one step ahead than the previous one, definitely, yes. And yeah, in terms of the parties not aware about what is there in the contract, definitely I'm still sticking to my earlier statement out here. Ignorance of law is not an excuse out here, but then ground reality, sometimes we really have to get into the practical or the cultural adaptation that we have in the country. I would say it's a cultural issue or the cultural adaptation. Sometimes it would be burdensome to read 106 pages of the standard bidding document excluding the contract agreement, and yes, we have the literacy rate in the adult population of 66.6% right now, but then how much literacy rate do our Bhutanese contractor have in terms of the contractual legal point of view? And that is a very questionable Seshuni, and there is no scientific study done as well. But then my paper is in progress, and I'll definitely include Tandin sir's input out here. Seshunila, thank you so much.
I saw Satash Tilak's hand being raised, but before that, Madam Sonomyangjan, your hand is still raised. Do you still want clarification? If then we'll hear you, let Madam Bigmar answer, and then move to Satash Tilak.
No, Kunzang, I'm so sorry. I couldn't put it down. I'll do it immediately.
Last, Madam. Last, Satash Tilak, do you still have your question?
Thank you, Kunzang. Can you hear me?
Yes.
Okay, this is not exactly a question, but perhaps I'll take this opportunity to actually just raise a comment, especially in the context of what Migmar is actually doing at this point in time. Maybe some sort of feedback or a comment that might assist in her doing a little bit more research into it. See, one of the main reasons I think the mandatory binding clause in the procurement law that we have, and as already clarified by the other participants, I think this is something which has already been addressed as of now. But beyond that, I think we also might want to look at the reason why people are not really resorting to arbitration. The fact that we have enacted the ADR Act in 2013, MOSHLA, the Alternative Dispute Resolution Act, which actually tries encouraging arbitrations in the country. And at this point in time, what we are the resentment against arbitration is purely because I think, again, this is just a conjecture that based on anecdotal narratives from people who've actually been through the arbitration process. What they often say is that they really do not trust the process that is involved in arbitration. I think the question that we need to look at is, why do we not trust arbitrators? When the whole world is moving towards arbitration, especially in business areas where arbitration is the preferred mode of actually settling disputes, which is supposed to be faster, speedier. Why do we have this resentment, this suspicion of resorting to arbitration in Bhutan? And the second thing that we can look forward is the fact that we have a Bhutan Alternative Dispute Center, which primarily looks at settlement of commercial disputes. If we are trying to take this away from them and then dumping it back to the courts, are we really moving ahead, Sela? Just a comment, just a thought. Thank you.
Laszlo, with that very wise comment and some food for thought for us, especially those lawyers and those in dispute resolution, and in fact, even public procurement, because this is at the end when a dispute happens, this is what is happening right now. So this is a very wise comment to end our panel on. I want to thank all our participants for this very interactive session, and also thank all our panelists. A round of applause. We will now break for lunch, and hopefully everybody is able to join at 2. Thank you.